I'm pleased to turn to Senator Whitehouse, who, of course, is a distinguished member of the committee, but I want to repeat my compliment to him on the excellent work he did in helping reveal this problem of executive orders being rescinded in secret. I thank you, and I turn it over to Senator Whitehouse.
Thank you, Mr. Chairman. I appreciate those kind words very, very much. Mr. Berenson, you and I probably disagree on a great number of things, but I have to tell you that I was impressed by your testimony. I found it very lucid, very disciplined, very thoughtful, the sort of thing that I would hope to find in OLC opinions and recently have not. But if I accept your proposition, as I think most people do, that there is a necessity for secrecy in various aspects of government operations, and that necessity for secrecy in turn provides benefits back to the public through public safety if it's being done correctly. I would suggest to you that when an administration chooses to exercise the privilege of secrecy that it is given, when it chooses to pull that mantle of secrecy over its actions, it undertakes at the same time a very high and solemn obligation to use that zone of secrecy in a proper way for two reasons. First, it's just indecent not to, and it runs contrary to government principles in our American system of democracy. But from a practical point of view, if you foul the nest, if you will, then you create the skepticism and the concern that Congress has now, and you create the risk that we will tighten down on these security issues, and fundamentally you put future administrations and the public safety that it's the very purpose of secrecy to safeguard in the future at risk as a result of having done it. It's kind of a complex version of crying wolf. And I'd like to hear your reactions to that analysis.
Thank you, Senator. I think I can say that I'm in complete agreement with that analysis. Both of the reasons you identify for exercising the privilege to keep something secret I think are exactly correct. There are manifest benefits to open debate, discussion, and criticism that you lose when something is secret. And as with almost any authority, when you abuse it, you undermine the rationale for having it in the first place, and you threaten it in the future. It is very difficult day to day, operationally, inside the government, as all of this is happening in real time through the Department of Defense and the intelligence community and the White House, to find a good way to police it and to guard against abuse. There are inevitable self-interested tendencies that cause people to use this power when they have it, and some of those have been alluded to by other members of the panel. It is a way to win a bureaucratic war sometimes by controlling information, to insulate yourself from criticism, to essentially get your way. And you can convince yourself, delude yourself into thinking that you're making something secret in order to protect the larger national security interests. Ultimately, it comes down to the judgment and good faith of the individuals who serve in the executive branch. I'm not sure there's much other alternative, and it's why another of this body's powers is so vital, namely the power of confirmation.
Let me ask you a quick, admittedly hard question. To the extent that the opinions, classified opinions of OLC have been made public and you are familiar with them, do they meet that high standard?
I think that this is another area where being at 5 years distance from my own government service gives me a little more freedom and a little more perspective. I do think that there is a strong argument that some of these memos that we've been discussing this morning should not have been classified, and that they did not comport with the standards that we've been talking about. Part of the reason for that, I think, is that they were constructed structurally in a way that I don't think they should ever have been, or that any OLC opinion should ever be, namely divorcing the discussion of law from the facts to which it's applied. OLC should be asked concrete questions about particular policies and practices and render an opinion no broader than necessary to answer that specific question. That fundamental flaw, that original sin in the way these memos were constructed, I think led to the creation of an opinion that probably shouldn't have been classified, but in the minds of the classifiers was, because it was part and parcel of other things that were going on around it simultaneously.
Let me ask Mr. Leonard a quick question, because he's the person with the greatest expertise in the classification process I've ever had the occasion to come across. And I was interested on page 6 of his testimony where he indicated, where he quoted Jack Goldsmith's observation that before Mr. Goldsmith arrived at OLC, not even NSA lawyers were allowed to see the Justice Department's legal analysis of what NSA was doing. Now, that implies to me that the legal analysis supporting a classified program is more highly classified than the classified program itself, because clearly the NSA knew what the heck was going on. They were doing it. So why on earth would NSA in any respect be prohibited from seeing legal analysis? In what world does it make more sense for the legal analysis supporting a classified program to be more highly classified than the program itself?
That's an excellent observation, Senator. I mean, I have a very simple question I ask whenever I encounter this type of situation is, who are we trying to keep the information from? And when you answer that question, who, that often will tell you then the why. Why is this being applied? As Mr. Barrison pointed out, and as I have, it's often done because of internal bureaucratic struggles.
Well, I won't. Will we have a second round, Mr. Chairman? Yes, sir. Okay, good. Thank you. I won't go into it in any great detail at this point, but I think as the panel knows, that my concern is that the administration took advantage of the secrecy of OLC to violate, I think what Ms. Johnson has well described as the long-standing practices of the Attorney General, the Office of Legal Counsel across time and administrations, in order to essentially cook the books in ways that would not survive peer review, and therefore they wouldn't expose it to peer review. And as a result, these sweeping and, at a minimum, highly questionable legal theories were propounded in these opinions. But my time has expired.